Okay, the clerk can go ahead and call court to order.
Court of Appeals for the 8th District of Texas, it's now in session.
Good morning. We're here today on one case, cause number 08-19-00179, Civil, Press Energy Services, LLC, and Christopher James Nisley versus Javier Bustillos Ruiz from Reeves County. We are broadcasting on YouTube for anyone who's interested in watching the proceedings. We are conducting this proceeding by Zoom via the Texas Supreme Court's latest emergency orders. So with that, Mr. Cathy, you may proceed anytime you are ready.
Thank you, Your Honor. May it please the court. The multi-million-dollar verdict in this case is orders of magnitude higher than the plaintiff's modest medical expenses and the highest verdict in a directly comparable case. Several critical evidentiary errors by the trial court and its gatekeeping functions, as well as the improper arguments presented to the jury, deprived the defense of a fair trial and precipitated this substantial verdict. The appellee concedes that at least one of these evidentiary rulings, the exclusion of any reference to his $57,000 in medical bills, was harmful if erroneous, and accordingly would furnish grounds for reversal of the judgment below and a new trial. Because the decision to remand the case for a new trial would allow this court to sidestep or at least substantially narrow the remaining issues on appeal, I'd like to begin with that exclusion today. While the appellee does not address or dispute harmfulness, it's still important to recognize at the outset that the harm from the exclusion in this case is not the excessive verdict. The harm from the exclusion of the medical bills is that the defendants were deprived of an important potential jury argument. Thus, the court does not need to find that the jury's verdict was excessive to provide for relief from the judgment below. Though the jury's award was excessive, as I will discuss today, the judgment must be reversed if the jury, not this court, might have awarded a different amount of damages if it were allowed to consider the medical bills. The surest indication.
Excuse me, Mr. Cathy, just so, what would the jury argument be that you believe would be significant?
The clearest example would be just to place the plaintiff's astronomical damages request into, bring it back down to reality. The plaintiff requested $14 million in non-economic damages based off of $57,000 in medical bills. Of course, the jury never got to hear anything about the $57,000 in medical bills, but really without the economic tether to the plaintiff's medical bills, the plaintiffs could have requested 30 million, 100 million. The plaintiff's imagination and the jury's imagination was really the outer limit to the award in this case. And so that would have been the principal argument, would be to place the claim for non-economic damages in the context of the broader claims for damages that the plaintiff could have recovered in this case.
Mr. Cathy, if I could ask you a couple questions about that. First, I understand your position from your brief about needing objective measures to put everything in context. But with the medical records, wouldn't you already have the number of doctor visits that the gentleman have? You would have an impairment rating, I assume, on the various injuries. If you have physical therapy records, you're going to have range of motion. Don't you already have a lot of objective measures that are in the record already?
Not in monetary terms. And that's part of the issue with the request to award dollar damages for non-economic damages. You need to convert something that's non-economic in nature into an economic dollar figure. And so the easiest and the best proxy or rule of thumb that has ever been devised is the medicals that the plaintiff has incurred. Parties use them in settlement discussions. Juries use them as rules of thumb. Reviewing courts in other cases have recognized they provide a valid rule of thumb to assess these non-economic damages.
But if I can just push back on that a little bit, you have medical bills, and the amount really depends on who's paying them. So if I'm paying them directly, they're one amount. If they're paid by Medicare, they're going to be another amount. If they're paid by Medicaid, they're going to be a whole lot less. And I guess these were all workers' compensation, so those are geared towards a fee schedule. So I guess my question is, of what value is that really to a jury who maybe really is only concerned about what their out-of-pocket or their deductible would be when they go to a doctor?
There's 2 points, Your Honor. The first point is that the paid and incurred statute and the Supreme Court in Haygood really addressed the question. And so the question is, what are the paid and incurred medicals? What the quote rack rate or the billing rates that some of these insurers, or excuse me, some of these hospitals and medical providers establish, as sort of an on-the-shelf rate. Those are never paid really by anybody. And so those don't really provide any real basis to award damages. And so the Supreme Court in Haygood excluded any reference to unpaid and unincurred expenses. And so the $57,000 in medical bills, in this case, importantly, were all paid and incurred medical expenses. So those would be admissible and recoverable damages if the plaintiff had elected to pursue that issue in front of the jury. The second point I'd like to raise is, the plaintiffs in this case have taken a pretty broad view of opening the door with respect to the DOT letter, which we can discuss later. But with respect to the medical bills, even if the hospital visits and the actual, underlying medical conditions that are diagnosed in those records provide one indicia that the jury could have relied upon in order to establish the amount of non-economic damages in this case, surely the amount that were reflected in those bills also provides another indicia. And so by relying upon the medical bills, the plaintiffs essentially open the door to allow the medical bills, the amount of the medical bills into the record. The concern in this case was by excluding the amount of the medical bills, the jury was left with the impression that there were, potentially hundreds of thousands of dollars in medical bills. And so that's potentially the basis for the jury's verdict in this case, was the false impression that the exclusion of the amount of medical bills left the jury with. And so that is a potential basis and a probable basis on which the jury awarded several $1 million in this case.
So if I can ask just one follow-up, Mr. Kathy, just how are these bills relevant? I can imagine, suppose a person has some type of medical treatment that is extremely expensive. Does that then mean that the jury could decide that the value of pain and suffering is equivalent to the expense of the bill, as opposed to another person, who may have a tremendous headache, but is able to cure the headache with the very low cost over the counter treatment. And so then that value of pain and suffering is very little. So I'm trying to understand how a jury would be receiving this information, not as a point to assess the medical cost, but to assess these damages, and help me connect up where the relevance is.
Correct. The point is that really the amount of economic damages isn't the only arrow in the quiver. It's a substantial one, but it's not the only one. And so there's not going to be a dollar for dollar correlation in every case. And so the fact that you have, low economic damages in one case doesn't necessarily mean that there's no pain and suffering, but there is a correlation and a very real connection, as recognized by the cases we've cited and the rule of thumb applied by, juries and parties in settlement negotiations. And so that's really the important point, is that in the same way that you can look at the force or the dynamics of an accident and say this was a very forceful injury, and you can look at those dynamics and say that likely increased the amount of pain that this person suffered. That's not always the case. You can have catastrophic accidents where people walk away completely uninjured. But in that case, you still don't exclude any reference to the accident by saying, there's outlying cases where the amount of force and the impact didn't correlate with the injuries in a specific case. That's certainly not the case. And so I think that the relationship still, as a general rule of thumb, it exists. And we know that from the case law. And so just the fact that there's not a dollar for dollar correlation doesn't mean you can't admit that evidence. And the nature of the injuries is another indication of that. My threshold for pain may be different from your honors. And we don't say, the fact that everybody experiences pain differently, we can't compensate it because, I may not feel a broken arm the same way you do. Still, we allow the jury at the end of the day to rely on common experiences and the aggregate totality of the circumstances to assess the amount of reasonable compensation. And certainly the dollar amount that somebody incurs in medical bills it is one of those tools that needs to be brought to bear in this type of case, Your Honor. So, the plaintiff acknowledges that if he had asked for an award of economic damages, his counsel and the jury both could have relied upon those damages as a basis for the non-economic damages calculation. However, he claims that the defendants in this case somehow don't enjoy the same option to introduce the exact same evidence and make the exact same arguments. That position defies basic notions of fairness, the rules of evidence, and the case law from virtually every other state court to address this question. In their briefing, we've cited to those cases that basically state that the liberal standard for relevancy under Rules 401 and 402 permit the defendants to introduce the amount of medical expenses to contest an astronomical non-economic damages request. The plaintiffs have really two lines of attack. The first line of response from the plaintiff is based upon the Texas Supreme Court's decision in Haygood and the Fort Worth Court of Appeals decision in Gordon versus Redelsberger. Those decisions, or the reliance on those decisions, is really misplaced. Haygood, as I alluded to earlier, says only that paid and incurred medical expenses may be admitted because those damages are only compensable by statute. The bills in this case are all paid and incurred, so there's no issue under Haygood. The plaintiff's economic injuries were compensable and recoverable within the meaning of Haygood. The plaintiff simply made a tactical maneuver not to press the issue in front of the jury. Similarly, Gordon only held that the bills in that case did not demonstrate the damages awarded there, which was only a small fraction of the award in this case was excessive. However, as I also noted, the question at issue really is not about excessiveness. It's whether the exclusion was harmful, and the test for harm is whether the bills could have contributed to a different award. And the appellee doesn't dispute that is the case, and surely it is. The intentional effort to keep out the bills demonstrates that they would have influenced the jury. So there really can't be any dispute about that. And so recognizing the limits of those authorities, the plaintiff also suggests that the exclusion issue, perhaps the most salient and extensively briefed issue in the entire case, can be disposed of on the procedural ground that the medical bills were not raised as an affirmative defense or disclosed under Rule 194.2. Putting aside the fact that the affidavits for all of the billings were filed and all of the providers were identified in discovery, the end result is just that medical bills simply are not an affirmative defense. An affirmative defense is an independent ground upon which the plaintiff should not recover, even if he establishes every allegation in his petition. Not merely one ground that serves as a denial or a rebuttal to the plaintiff's claim. Plaintiff's medical bills are merely one source of evidence for disproving an inflated damages request. They're not an affirmative defense. Furthermore, under Rule 194.29 or 0.2D only requires the defendant to state the amount and method for calculating economic damages be disclosed. In their briefing, the plaintiffs rely upon comment 2 to Rule 194.2, but that comment is actually emphatic on the point. It expressly states that the rule, quote, does not require a party, either a plaintiff or a defendant, to state a method for calculating non-economic damages, such as mental anguish. And so for all these reasons, the court should reverse the judgment below and grant a new trial on all issues to allow the jury to consider the plaintiff's medical bills. Without knowing the amount of the actual medical expenses in this case, the jury awarded $3 million in non-economic damages, including $250,000 in future mental anguish, $1 million in future physical impairment, and $250,000 for disfigurement. Yet there was no expert testimony that the plaintiff would require any future medical care or suffer any future pain. The most a jury had previously awarded for any similar injury was approximately $200,000 for a rotator cuff and 2 broken wrists. And nearly all the verdicts were far less than that. Obviously, this court's not bound by the maximum recovery rule applied by the Fifth Circuit, but that rule certainly provides a helpful basis for considering excessiveness. And under that rule, these directly comparable verdicts, the award would need to be reduced, orders of magnitude to somewhere around $300,000. While all of the awards in this case are unsupported, it's probably appropriate to start today by focusing on the largest component of the jury's award, which is also the one with the scarcest evidentiary support, and that's the award for physical impairment. As the Supreme Court recognized in Golden Eagle Archery versus Jackson, when pain, mental anguish, and disfigurement are awarded, as in this case, there's often little left under the category of physical impairment to compensate. Here, the jury awarded over $1.75 million for physical impairment, in addition to the $1.5 million award for physical pain, mental anguish, and disfigurement. Yet most of all of the impairments alleged by the plaintiffs overlap with his claim for physical pain, mental anguish, and disfigurement. The only really arguable independent impairment in this case is the plaintiff's inability to fully close his pinky finger from what they call a boxer's fracture he suffered in his 5th metacarpal. And he claims that made his handshakes feel differently and might cause him to drop small items. But there's simply nothing in the record to support the jury's award of $1.75 million for that impairment. The plaintiff did also complain about headaches and being more quiet and reserved after the accident, but there was zero medical testimony in the record showing that the plaintiff suffered from depression or any other testimony linking his headaches with this accident. There were CT scans of the plaintiff's brain after the accident. They all showed normal function. In the absence of any medical testimony on those issues, the appellee really is forced to rely upon the logical post hoc fallacy that says, because he's testifying that he had headaches after the accident, we have to assume that the accident caused those headaches. But that really creates nothing more than suspicion of an injury or causation, which the Texas Supreme Court has said is not evident. Notably, the plaintiff also relies upon, his injury to his knee and a rotator cuff. But the evidence in the medical records actually show he had issues with his knee and his rotator cuff that were chronic in nature. And most the accident did was potentially exacerbate these underlying issues. And the issues with his knee and his issue with his left thumb and the rotator cuff were almost entirely eliminated by the time of trial. And so turning to another substantial component of the award, which was the disfigurement award, the plaintiff lost a small bit of cartilage from his ear, and he had minor scars associated with having his shoulder scoped. For comparable injuries, courts have affirmed awards in the low single digits, around $3,000. There's simply no precedent for a $500,000 award in this case. In their briefing, the appellee cites some larger verdicts, but those cases all involved substantial burns or degloving type injuries that resulted in profound disfigurement, where there were multiple skin grafts that required numerous surgeries and prevented the plaintiff from being able to wear shirts or shorts or swim. And that's just not the record in this case. And so the final element of damages in this case was the element of pain and anguish. So following the accident, the plaintiff did obviously experience some pain and embarrassment associated with his inability to care for himself. But that situation was temporary. There was no testimony he was currently in pain from his hand or his knee or was able to care for himself. And there were no issues with real, underlying mental health complaints. And so there just is no evidence to rise to that high degree of, mental distress required to support a substantial mental anguish award. And it certainly doesn't support the $3 million award in this case. So the court should order a new trial on that basis, or at least substantially reduce the awards. I see my time is running short. And so I just would like to briefly address one other potential basis for the court reversing the judgment below and granting a new trial. And that's the trial court's erroneous rulings with respect to the out-of-court statements made by Nick Kasner, a consulting-only expert for one of the appellants. Kasner's out-of-court statements were obviously hearsay. They were made outside of court in his role as a consulting expert, not as a party representative. And they weren't present sense impressions because they were purportedly expert opinions and calculated statements. The whole reason the appellee's expert Will Miller cited Kasner's alleged statements was as validation for his expert's opinions, which Miller testified or claimed that Kasner, purportedly talked with him about length about. And so if they were present sense impressions, they would have been cumulative of the photographs reflecting the then existing condition of the press energy tractor trailer at the inspection. But the appellee and your expert, excuse me, Your Honor.
Counsel, if I could, was this issue raised at all pre-trial, or did it just come out in the direct examination of Mr. Miller?
It was briefly raised at pre-trial as one of numerous limine topics, but the limine topic really attempted to address something a little bit different than ultimately how the issue came about at trial. I guess in the deposition of Mr. Miller, he made some reference to this being a joint inspection and that providing support, but he didn't go into the detail that he did or make the claims he made at trial. And that was principally the fact that the conditions he noticed on the truck predated the inspection. And so it was one thing to say that this was a joint inspection, but it was completely different, which was, after the objection was raised and the plaintiffs knew that the trial court wasn't going to stop them, they really hammered Miller to elaborate and expand upon, not only was this a joint inspection, but Kasner agreed with everything I said, including things that pre-existed this accident. And that's really the only fact of consequence in this case.
And I think maybe the context of my question is, in the direct examination, Mr. Miller is asked, I guess he's detailed some of the problems with the brakes. And he says, which one of these violations that you have on Exhibit 1 did Press Energy's expert disagree with you on? And then he gives an answer, but there's not an objection to that question. But then subsequent, I guess another page, in the next page or page after that, then there is an objection. So that's the issue that I'd like you to focus on.
Correct, Your Honor. I apologize for misapprehending the question. But the objection, to start out, the objection doesn't need to be immediate in order to be timely. Timely is the standard. And so in this case, it was obviously timely because the issue was raised, 2 pages later, and the trial court overruled the objection. So the notion that another objection 2 pages earlier would have changed the result, I don't think is correct. But to address your point, the initial testimony didn't relate to the question of whether the brake conditions pre-existed the accident. That's the only question of consequence. So the failure to object to that first reference to the existence of a joint inspection and the notation of potential issues at the inspection can't possibly waive the objection to the subsequent and separate issues and testimony that stated that all of the conditions predated the accident. And so that's really the harmful admissions in this case, Your Honor. And so the issue was preserved for this court's review. And under, every established test for harm, the admission was harmful. The plaintiffs didn't return to it one time or two times or three times. They did it over a dozen times. And compounding the harm from the admission was the trial court's refusal to allow Mr. Kasner to testify because he wasn't designated as a testifying expert. If that rationale justified anything, it justified excluding Will Miller from referencing Kasner's alleged statements in the first place. It was just profoundly unfair to say an undisclosed consulting expert statements are admissible by one party, but are inadmissible by the other party for purposes of rebutting the alleged statement. And so for those reasons, Your Honors, Press Energy and Mr. Nisley would request that the court reverse the judgment below. Thank you.
Thank you. Mr. Waldrop?
Thank you, Your Honor. May it please the court. I'm Alan Waldrop, and I'm here on behalf of the appellee Javier Bustillos. Just because of primacy, I'll take up right where we left off, with the court's permission, and that is the statements of Mr. Kasner. I think that Your Honor, Justice Alley hit the nail on the head, and I would refer the court to the actual record. What you just heard about what the testimony that came in completely unobjected to is not correct. And I think just having it short, and I'll read it. There was an answer where Mr. Miller said, this is a joint inspection. So in other words, this was an inspection that was conducted by not only myself, but there was expert for the defendant that was present at the inspection. So we went through the process of actually going over, and we inspected each chamber, each different section of the tractor and the trailer together. And when a violation was found, we would look at each other's measurements, verify that we agreed what the measurements were. And so that way there was no disagreement that there was a violation or it wasn't a violation. He goes on to describe for a few sentences of who it was that he was dealing with here. It was Press Energy's expert. He knew the guy. He knows he's an expert in the fields, worked with him before. And then he said, and that wasn't objected to, no objection. Then he says this. The question is, okay, all right. Now you mentioned that y'all went through it together. Which ones of these violations that you have on Exhibit 1 did Press Energy's expert disagree with you on? Answer, there were no violations found that were discussed and found that are on the board that were not agreed upon. We searched, we looked, we investigated, we conducted a reconstruction. Part of the reconstruction is doing a DOT inspection. And so this was done together. There was no disagreement on what we found. All of that evidence came in unobjected to. And the idea that you can make an objection after the jury has heard the evidence is simply not the law. This idea of, well, a couple of minutes or a few pages later is okay. It is not okay. An objection has to be, the law is clear. An objection has to be timely. It has to be lodged when the evidence is coming in and when the jury is hearing it. And frankly, this objection was plainly not timely in any shape, fashion, or form. Now, even then, once it was made, there's another couple of problems with it. Simply saying that they're going to object based on hearsay is not sufficient to keep Mr. Kasner's statements out, because the hearsay rule also includes, as the court is well aware, the opponent party admission rule, opposing party statement, which is Rule 801E2, and it includes when a party's agent or employee on a matter within the scope of that relationship and while it existed. There is no dispute in this case, and the appellants have never disputed that Mr. Kasner was in fact a retained expert by Press Energy. He was a retained agent. He was there on behalf of Press Energy conducting a joint investigation on behalf of, and at the request of Press Energy. That's not disputed.
Does it make a difference though, counsel, that he's a consulting expert? I mean, when I was in private practice, I hired lots of consulting experts to hear what they had to say, and I may end up designating them, I may not, but it's not like I'm adopting everything that the consultant has said until the point that I've designated him as a testifying expert.
it actually makes no difference whether he was a consulting expert or not a consulting expert, because that distinction has to do with whether or not something is discoverable, not whether it's admissible. Now, if you can keep your consulting expert opinions confidential, you can prevent them from being discovered. But if that consulting expert comes out and renders opinions, they are discovered, and admissibility becomes a question of, is it admissible under any other rule of evidence, which is it relevant? Does it come in for any other reason? Now then, the idea here is that there's no question that he was one of the party's agent at that joint inspection. He was sent there to represent Press Energy as their agent. That's not disputed. There hasn't been an objection lodged on that. That hasn't been argued that way. He was there on behalf in this joint investigation on behalf of Press Energy, and the statements he made were during the joint inspection, and so were certainly within the course and scope of the relationship while the relationship existed. To turn around and say, well, we're going to avoid those non-confidential statements. We're going to avoid those non-confidential, that non-confidential evidence that was given to our expert. And by the way, don't forget, our expert under the law is entitled to rely on or to use hearsay statements if he wants to. He can certainly recount them if they were part of his work. And so I would suggest to the court that the idea that the non-consulting expert issue comes into this is frankly just a red herring. And so the final point on that is there is absolutely no way that any introduction of Mr. Kasner's statements or thoughts in that meeting could be harmful error in this case. We have argued that it was harmless, and the standard is this. Part of the standard is from the case law that whether there was contrary evidence that existed that the improperly admitted evidence was calculated to overcome. So even if you assume, even if the court were to assume that Mr. Kasner's statements should not have come in, and assume that, hypothetically, then there had to exist contrary evidence that his statements would have overcome. And in this record, here's the state of the evidence. It's almost unbelievable. I've not seen it like this in my career, except for this case. The defendants did not call any expert witnesses. They didn't call any expert witness to contradict Mr. Miller's testimony. There was no contrary evidence, literally no contrary evidence in the record to what Mr. Miller said and to the opinions that Mr. Miller gave. So
excuse me, counsel, I thought the mechanic testified that when he looked at the ABS brake line, that it looked like it was broken and not cut. I mean, wasn't that kind of your theory that the system was cut and intentionally dismantled? And his argument was, the mechanics was, these trucks go through the brush and the wire gets caught up and it could have broken.
The mechanic did in fact say that. Mr. Gary Ralston, who was the head of the shop, did in fact say that. He was not an expert. He was not offered as an expert. His opinions were not offered to contradict Mr. Miller's opinions. He did testify to that, Your Honor. There's no question. Now then, what I'm trying to make the point about is that there is no expert testimony, none in this record that contradicts Mr. Miller. And so even if this was improperly admitted, Mr. Kasner's statements, which they were not, it could not possibly be harmful error. Now, the primary issue, I'll just get to it right quick, and that is, this is the $10 issue in this case, and that's the exclusion of the medical bills. And the reality is the only law that currently exists in Texas on this point and is directly on point is the Haygood case and the Gordon versus Rettelsberger case. And I'm just going to call it the Gordon case with the court's permission rather than the Rettelsberger case. Those two cases are unequivocal. They're directly on point. They're the only case law in Texas, and they make good sense. Haygood just flatly says evidence which is not relevant is not admissible. This includes evidence of a claim of damages that are not compensable. Haygood goes on to say, Haygood's solution to the problem, meaning the problem of one party wanting to offer evidence of non-compensable damages and the other party not contesting, not wanting that done. Haygood's solution is to allow the jury to consider evidence of non-recoverable economic damages in setting non-economic damages, the exact point that is presented here. The court goes on, but we think that any relevance of such evidence is substantially outweighed by the confusion it is likely to generate, and therefore the evidence must be excluded. The statement in Haygood is unequivocal. It's Texas Supreme Court authority. The fact that it came up in the context of a plaintiff trying to get in evidence, irrelevant evidence on damages, as opposed to a defendant trying to get in irrelevant evidence on damages, doesn't change the nature of the holding. The holding is plain on its face. But more importantly, we would ask the court to look very carefully at the Gordon case. It is a 2019 case out of Fort Worth, and the court probably already has, but the Fort Worth court, knowing it is writing really as the first case after Haygood to take on this issue directly, the Fort Worth court, in my view, really does a nice job of doing a thoughtful, careful, elaborate analysis of the issue and the issues that surround what goes on. And I'll just note a handful of things that the court, in its rather lengthy opinion, said. Further, the fact that the amount of non-pecuniary damages, of course, that is a reference to non-economic, those are interchangeable, far exceeds the amount of medical expenses incurred by a party does not signal a lack of factual support. And now this is in the context, I'll just digress very briefly to this court's opinion in Sanchez versus Valderrama in 2017, in which this court dealt with directly with a case that had no economic damages involved and only non-economic damages. And the court laid out in great detail the standards for a reviewing court to review a jury's award of non-economic damages. And the court made it very clear that the jury resolves any inconsistencies in a witness's testimony because there are no objective guidelines to assess the monetary equivalent to such inquiries. The jury is given broad discretion in awarding an amount of damages it determines appropriate. The jury's province is to resolve the speculative matters of pain and suffering, future pain and suffering, future disfigurement, and the future physical impairment, and set the amount of damages attributable thereto, as long as sufficient probative evidence exists to support the jury's verdict. This court will not substitute its judgment for that of the jury. On appeal, we will set aside the verdict only where the record clearly indicates that the award was based on passion, prejudice, or improper motive, or is so excessive so as to shock the conscience. Now that's the standard that this court quite rightly recited. It's been the standard, those have been the standards for a long time. And the Gordon court picked up on these standards and then looked at them in the context of a case where there was economic damages. And they
Mr. Waldrop?
Yes.
I'm sorry, you're running out of time. So I just wanted to ask you if you could address some of those compensatory damages amounts that are being challenged.
Yes, let me do that. First of all, what the appellees want to do is two things. They want the court to adopt their narrative of the facts rather than follow the standard of review, which is you have to defer to the jury's view of the facts, which the court knows. What they're asking the court to do just openly is to reweigh the evidence to decide what the court thinks this pain and suffering is worth. This court knows that that's not the standard of review and that's not what the court should do. Now, another thing that the appellees are doing is they're gathering the cases that they find that they think have the lowest damage awards to compare this case to, and they are just completely ignoring and just acting like they don't exist, the cases where there are higher ranges of awards. And those cases include, let me make sure I've got my list, Primoris Energy versus Myers, Marquette Transportation versus Jackson, Casas versus Paredes. All of those cases are cited in our briefing. They are cases with significantly greater pain and suffering, non-economic damage awards. And so the point of that is this. This court is not trying to find a correlation between numbers. That's not the court's function. What is clear from the case law is that this court is just trying to find out if the award is outside of the acceptable range, meaning it's way too low or it's way too high, such as it shocks the judicial conscience one way or the other. If it doesn't do one of those two things, then that award needs deference and the court should affirm it. And the awards in this case are certainly in line with awards of non-economic cases and damages in other cases. And I'll say this, the defamation cases that are cited and relied on by appellees have no bearing at all. They are comparing two different types of non-economic awards themselves, which are awards to reputation versus mental anguish. They have no bearing on what we're talking about here, top, side, or bottom. But it is absolutely, and if you want to look in the record is replete with evidence of the harm. And I was just making a list, which I'm trying to find here, of a quick short summary list while he was answering questions. Trying to minimize the harm that Mr. Busillo suffered is not a fair thing to do. Looking at the evidence is what must be done. Mr. Busillo lost 90% of the function in one of his hands. The other hand dropped from 120 pounds of gripping ability to 29 pounds. The movement of his right hand has been restricted so he can't properly close it and fingers don't bend properly. He has recurrent shoulder pain that will last the rest of his life. He's got headaches that will last the rest of his life. He's got an injury to his knee that prevents him from running and from having full mobility that will last the rest of his life. All of these injuries are permanent and they are the fault of the defendants. None of those, but the jury gets to listen to that evidence and gets to weigh it. And as long as they've not gone completely off the rails, meaning completely outside the realm of reasonableness, then deference should be given to their judgment. And that judgment should be affirmed. None of these awards do that. I'll note, the jury did not award even remotely close to what the plaintiffs requested in this case. They substantially reduced those awards. The jury was careful. They were careful to pick different amounts in different categories. That showed they were thinking about what they were doing. It showed that they were thinking about the nature of the impairment. There's permanent scarring. There's permanent loss of part of an ear. There's a lot of permanent injury here that he's going to have to live with forever. And consequently, that's where they put the largest award. That is evidence of a jury trying to be reasonable and trying to make sense of what they are doing. It is not evidence of a jury just putting a number in a blank. Now, the question that was asked by Justice Palafox is really, really a good one here. And that's the fundamental question, and it is a question that if answered from a legal perspective correctly, it solves this entire issue. What is the relevance? The relevance of the medical bill evidence to come in and how would the jury use it? And in that context, I'll note something. There is no evidence that $57,000 in medical bills that the defendants wanted to offer is in fact all of the medical expenses. There's no evidence of that. There's a reason for that. It's because over 3 months before trial, plaintiff dropped that claim. There was no longer a need to supplement, and so plaintiffs did not do that. The significance of that is this, and this goes to the affirmative defense and discovery issues. If plaintiffs are going to face evidence of medical expenses to be argued that it should somehow lower the non-economic damages, then the defendants need to give us adequate notice and fair notice of that. There was no fair notice of that. They didn't plead it. They didn't put it in their discovery responses, in their request for disclosure responses on economic damages. They said none. The answer to that was none. There was absolutely no notice that what was going to happen at that trial is that the plaintiff was going to argue against our non-economic damages by trying to prove up economic damages. That is, they ought not be allowed to do that. Now, it would be a very interesting case, and we will, and it's my personal view, but not necessary in this case, that defendants can't do that anyway because the damages have to be recoverable, and they're not here. Economic damages are not recoverable. They weren't pled. They're not requested. They're not recoverable under Haygood. We're done here. But as a thought experiment, even if there was a way for a defendant to say, I should always be able to litigate economic damages if I want to, whenever non-economic damages are requested. If that were the law, which it's not, but if it were, then how in the world would you be able to do that in this fashion that was done in this case, without disclosing it, without saying what you're relying on? And bear in mind, the plaintiff is the one that has this information in its possession, and without getting all of the information. There is no question that $57,000 did not in fact encompass the universe of medical expenses. But even if those medical expenses and costs, and frankly, don't forget, medical bills are only one factor. They're not the quote signpost as referenced before. They're one factor. There are other economic damages, such as lost wages, lost earning capacity. Had all of that evidence gone in, and had it even produced a modest amount of, say, $200,000 or $300,000 worth of economic damages in this case, which it could well have had there been notice and an opportunity for us to marshal that evidence, then certainly we are all of a sudden within ranges of correlation that correlate to even the lowest awards cited by the appellees. And so,
Alder, if I could interrupt you, your opposing counsel, Mr. Cathy, opened his presentation by noting that Mr. Bustillos had not challenged whether the admission of that evidence would be reversible error or not. Was that challenged in your brief? I kind of hear you to challenge it now, but I just wanted to know whether it was challenged in your brief.
We did not challenge whether it was harmful error to admit that, but I will say this. I don't think we have to do that under the prevailing standard. The prevailing standard is this, that whenever an evidentiary ruling results in evidence being excluded, it's a question of abuse of discretion by the trial judge, and the court is always required under the applicable standard of review to review whether or not it led to the rendition of an improper judgment. That's the harmless error rule. It's part of the standard of review. And so I would suggest to the court, it is still part of the court's analysis, whether briefed or not. It's also not dispositive, but it is part of the standard of review.
Thank you.
If there are no further questions, if I've got any more time left, which I don't know that I do, I will be happy to cede it back, but I'm also happy to entertain any other questions the court has.
And for me.
Well, thank you very much. I appreciate that.
Thank you. Okay, Mr. Cathy, do you have any rebuttal?
I would like to make a few points, and I'll go in reverse order and start with the exclusion of the medical expenses. I'd just like to reiterate that under Haygood, all of the expenses in this case are recoverable. There was nothing preventing the plaintiff from recovering economic damages. There are a recoverable element of damages in a personal injury case like this. The plaintiff just strategically decided not to press that claim in front of the jury. Logically, the result.
Let me ask you, Mr. Cathy. So they can do it, but there's no law that they have to do it.
Correct.
Okay, thank you.
But the corollary is also there's no rule that prevents the defendant from doing the exact same thing that the plaintiff would do, and that is rely on the medical expenses as a tether for the non-economic damages. And so
okay,
all we're asking.
Let me ask you this. So you were free to pursue that in discovery and maybe, and introduce that evidence, through a business records affidavit to make that argument. You were free to do that. I mean, is there anything that bars you from doing that?
Well, the trial court's exclusion pre-trial was the only thing that prevented it.
No, that's not what I'm asking. I'm asking if you had properly gotten the records that had been up to date, if you had subpoenaed the custodian of records, if you had introduced them. I'm not talking about, it seems to me that you had the ability to do that properly and that wasn't attempted.
Your Honor, it completely was attempted. And the only admissible evidence in front of the court is the offer of proof of the billing records of the affidavits. I believe it's Defendant's Exhibit 13 that includes that information. So all that information was gathered and was presented at trial as an offer of proof. So all
Mr.
of that
Okay.
evidence is
Okay.
in the record. And-
Okay,
Excuse me, Your Honor.
but it wasn't complete.
I dispute that it wasn't complete, Your Honor. There's no admissible evidence in front of this court that it wasn't, that it was incomplete. But to the extent it was incomplete, that really is just mill for the trial stone, or grist for the trial court mill. Those factual disputes should be resolved in the trial court. And so
Okay.
if there is some factual dispute, that should have went to the jury, and the plaintiffs could have presented that and said, no, the amount is 100,000 or 50,000. This notion that somehow they had hundreds of thousands of dollars in non-economic damages they didn't pursue is just implausible on its face.
So
Logically,
can
yes, Your Honor. Excuse me.
I guess I have two questions. One of them being, what were the pleadings that caused these bills to be relevant from your perspective? And then secondly, now I'm losing my question, sorry, but all right, just answer that first question. Maybe I'll think of it.
Sure. I mean, the primary pleading was the request for $14 million in non-economic damages.
No, from the defense perspective, what was pled so that there's the fair notice? What was pled by the defense, since it's not an affirmative defense, but what?
A general denial which put the plaintiffs to his proof for $14 million in economic or in non-economic damages. And so the general denial placed at issue every factual dispute in the case. I mean, that's Texas procedure. We pled a general denial. So they knew we were contesting the amount of
the
damage.
problem, I guess, if somebody's not pursuing medical bills, then there's nothing to deny against.
Well, I mean, the plaintiff agrees that those were his medical bills. I mean, he was the one who obtained the billing affidavits and everything like that. And so, I mean, I don't think there's a dispute that as to like the factual amount. I think it just goes to the only question is really the admissibility. So I'm not understanding the lack of fair notice.
Counsel, were the record custodians who, I guess, proved up the bills, were they listed as persons with relevant knowledge in your response to requests for disclosure?
My understanding is that they were, Your Honor.
Okay,
All of these
and-
people were disclosed by the plaintiff and by the defendants, either through cross designation or separate designation.
And there would be, I guess, these 1801 affidavits that would be have been filed of record that you could tell, I guess, whatever the date was showing the last billing.
Correct. And
Right, yeah.
my understanding is that all those are already in the record. And so those were
Right.
made as part of the offer of proof, Your Honor.
And if you had been able to put in this information, I guess I'm just curious if the plaintiff said, okay, that's fine, but now I want to put in my lost wages so that the jury really understands what the economic damages were, would that have been okay?
I mean, certainly if that was what he was attempting to do from the outset. But logically, he wouldn't have done that because he knows that those wouldn't have supported his 14 million damages request. I mean, that's the whole issue is logically, I mean, when the plaintiff dropped his request for economic damages, his ultimate recovery should have gone down. So you'd have expected his own self-interest to have compelled him to pursue not only his claim for the medical expenses, but for the lost wages. The fact is, the plaintiff was cleared to go back to work, at least on restricted or light duty, long before trial. And so that's the whole issue, is the plaintiff wouldn't have done that. But to answer the hypothetical question, the medical expenses clearly have a stronger bearing on the amount of non-economic damages than claims for lost wages or things like that. But
Can I ask
certainly
then-
that would be a ruling for the trial court to have made. Yes, Your Honor.
Okay, so back to the plaintiffs are, I imagine, asking the jury for $14 million is what you're saying. Was that objected to at the time so that the trial judge could make a ruling of some kind to say that the request is, it's out of bounds, it's too high, it's something of that nature? Or was the request for $14 million never addressed by the trial judge?
I mean, this is part of the issue with the the pretrial disclosure rules. If you look at 194.2, the plaintiffs had no obligation under that rule to disclose the amount of non-economic damages they were going to request, or their calculation for those amounts. And so that's really, there was no objection because they didn't have any obligation to disclose it. And so basic notions of fairness suggest the same was true of the defendants in that case.
And let me tell you, Mr. Cathy, where my real issue with the non-economic damages is firstly relevance, but prejudicial versus probative. I mean, I still fail to see the link between the non-economic damages and the economic damages and how and why they should be tethered. Logically, I can't find a rationale for that. Other than it's some way to, I don't know, in some way you're going to use it as an argument to say that non-economic damages is somehow, some way tethered to economic damages, and I just don't think that's the law in Texas. And I haven't, I understand your opening argument to say, well, then it's completely untethered. No, it's not, because at the end of the day, there's sufficiency of those non-economic damages, and we have to look at that and measure that. And if evidence is insufficient, then the reviewing court has the ability to either reform or remand, if I remember correctly. So at the end of the day, I just don't think that the trial court's exclusion is beyond the zone of reasonable disagreement.
A couple of points. The first one is the notion that, we're to look at or give deference to the jury's findings and attribute broad discretion to them. That rests upon trust that the jury has been provided with all of the evidence that potentially bears on this issue. In the same way that, medical records showing a broken arm, how does that indicate pain and suffering? There's no logical connection. Some people are immune from pain. And so the fact that somebody breaks an arm, that is not necessarily the same as the existence of pain and suffering, but there is a connection between them. In the same way, the plaintiff in this case relied upon his medical records and the injuries disclosed in there as a source, or as one potential element for the jury to base its award on. So too should they have been allowed to consider the actual dollar amounts. I mean, at the end of the day, how is a jury to convert something like pain and suffering into a dollar amount? That's a very difficult thing to do. And surely the best indication is the amount that the plaintiff actually has paid in dollar figures.
I disagree. I absolutely disagree.
And that's Your Honor is entitled to disagree, but the jury may not have. And that's fundamentally the point. Is ultimately the question is, what would the jury have done with this information? And when you look at Lane versus Martinez and other cases, including Gordon versus Rettelsberger, the court in that case actually said that reviewing courts can consider the relationship between economic and non-economic damages in reviewing the case. So other people have looked at these and have found them relevant. And so for that same reason, the plaintiff's attempt to dismiss Gordon versus Rettelsberger it misses the mark. It doesn't make sense to say a reviewing court can look at it, but the trial court in the first instance or the jury can't. And I see I'm out of time, Your Honor.
Right. Are there any other questions? If not, okay, we will conclude argument. I thank both counsel for participating by Zoom. I thank you for your excellent briefing and argument today. Your case will be submitted on that briefing in the argument, and hopefully you'll hear from us soon. So with that, we are concluded.